Good morning, everyone. It's your Dreamers Together caseworker for CREDA. And on the other side of me, I have my colleague, accredited rep Elizabeth Royas. How are you, Elizabeth?
I'm doing good. How are you, Fee?
Good, thank you. Getting ready for the holidays?
Barely.
Same here. So we are on live today, and we're going to be answering any general AOS questions that you have. And, we'll go over some DACA and AP related questions as well. But for the most part, any DACA or AP related questions, head on over to that group. But I think for today, we'll be happy to answer as many as we can. I'm sure all of you are aware that as of October 28th, I believe, USCIS will only accept electronic payment filings, okay? And this comes in the forms of G1450, credit card transactions, and G1650, authorized ACH bank transactions. For those of you that do decide to file your packet with the G1450, the credit card transactions form, please make sure you reach out to your bank, your credit card, the bank that's associated with your credit card, just to make sure you don't have any issues once, USCIS just does process that G1450 to charge you for those filing fees, okay? And for those of you who decide to stick with the G1650, that's fine. USCIS will withdraw the funds straight through your bank. Those are called ACH withdrawals. Now, we have heard that, people are having a little bit of problem or issues filling out these forms, but really they're not that difficult, okay? Example, I'm the petitioner. I have filed the I-130. I have to have a G1450, or if I decide to go with the ACH transactions, a G1650. So I need a G1450 or a G1650 for the I-130 because I am the petitioner, okay? I need to pay that filing fee of $675 for the I-130. And how I would do that is I would fill out a G1450 or a G1650 with my name first, okay? At the very top of the G1650 example, it's asking for the petitioner or the requester. Well, I know as a petitioner, I need to have a filing fee of $675 for the I-130. So that G1650 will come from myself. My name as the petitioner will be all the way on top of that form where it is asking for the requester or the petitioner. Under that name, they're going to want your bank information for the G1650. It doesn't matter whose, you know, bank information you input, whether it be yourself or the beneficiary. Okay. As long as that form is coming from you, you are the petitioner. You're going to input your full name at the top and then the bank information at the bottom. Okay. And that G1650 will be $675 from the petitioner that's noted on the top where it says requester or petitioner's full name. The bank information, it really doesn't matter whether what you want to use yours or your spouse's. Okay. Again, everyone has to have their own G1650. Or if you decide to go with the credit card forms, G1450. But I prefer the G1650s. Why? At least I know USCIS will withdraw it, directly from the bank, and we'll call it a day. Um, I need one for myself. I need my name on one for the I-130. The beneficiary needs one for the I-485 as well. Okay. Again, top, the beneficiary will put in their full name and will whoever uses their bank information, whether it be the petitioner or beneficiary, will fill out the rest at the bottom. But that one will come from the beneficiary for the I-485, and that will be $14.40 in the box where it asks for the fee. So, summarizing, you need your own G1650 or G1450 for each form. Like the I-130 has its own G1450 or G1650. The I-45 has its own G1450 or G1650. And also, if you choose the permission to work I-765, that one has its own G14 or G1650, okay? Just to summarize a little bit how these forms work. You can't use one G1650 or G1450 for all the forms. Each form has to have its own. Let's see. I really wanted to just like kind of touch base a little bit on that.
Um, I personally, now this is just my personal preference as an accredited rep, is I prefer the 1650 over the 1450s.
I agree.
Prior to the administration change into, or prior to USCIS change in to electronic payments only, there used to be the option of money order, personal checks, or cashier's checks. I preferred money orders, personal checks, or cashier's checks because in the past with the 1450s, I did see that a lot of banks were blocking the payment from USCIS. They were flagging it. And so after a couple of times, maybe two or three times that USCIS tries to pull that payment, and because the bank is flagging it or was flagging it, USCIS could not retrieve the payment. So they had already opened the packets, medical exam, and they would send everything back because they couldn't get the payment. So then they switched to electronic payments. But I have been recommending my clients ACH. And so far, we haven't had any issues with the ACH. The only issues that we do see is if the ACH form is not completed in its entirety. It has to be completed in its entirety and it has to be signed. So you just may want to double check, make sure that that G1650 is completely filled out. You can also do again the 1450. I just don't recommend it, but it's up to you if you're preparing your packet at the end of the day, how you want to send your payment. If you are going to be doing the credit or debit card, I do recommend calling your bank ahead of time and let them know, hey, I have two payments or three payments coming out from USCIS, and that should, okay, allow your financial institution to process that payment. But again, sometimes they don't. So I prefer 1650s, but let me know what you guys think, what has been working out for you.
Yes, please keep us posted. Whether you file the G1450 or the G1650, we definitely want to know which one has worked for you. And if you haven't been so lucky in something, so either firm has not worked, one or the other, just let us know. We want to know. Keep us posted. Okay, so on another note, approvals. Okay, I-485 approvals. We have had some cases where they have been approved on the spot, and we have some that have not. Um, please don't stress out if you do not get approval on the spot. You know, um, it just takes time. Basically, maybe there are a few scenarios which may occur, which the officer can be very busy. Maybe they haven't gotten to your whole file, or they need a little more time or information, or even background checks. You could very well go to your interview and the background check hasn't fully cleared. So there are, you know, a few scenarios where, you know, there are reasons where you wouldn't get an approval basically on the spot. So don't stress over that. Just because someone's gotten an approval on the spot doesn't mean there's something wrong in your case. It's just taking a bit more time, for whatever the reason, whether again the officer maybe needs more information, or he needs time to review your case, or maybe your background check hasn't fully cleared. So there's not necessarily a problem or a negative outcome if you do not get an approval on the spot. I have cases that are still waiting months after they went to their interview. And some of them have waited 4 months, 5 months, 6 months. They've eventually came to receive an approval. It just takes time right now. So let's just, patience, I guess. Let's just have patience. Okay, let's go to some questions. Grace, good morning, ladies. Happy Friday. Thank you, Grace. Same to you.
Good morning, Grace. Hoping for a quick approval, Grace. And Grace said that I know she's in the AOS process too, so hoping for a quick approval.
I think we just spoke about this. Elias, hi, Elias. Hello. I had my interview last November 17th. I got a verbal approval that day, so the next day USCIS approved my I-130, but they haven't approved my I-45. Is this normal? And what is the average wait on approvals after interview? Thank you in advance. So basically, we've had a lot of cases similar to yours where they approve the I-130 on the spot or the next day, and now months go by and the I-45 is still pending. But just to let you know, do not worry about that, Elias. That is perfectly normal right now. We have to put that in the normal. And if you actually listen to Attorney Cook, he actually spoke about how he was not able to file an inquiry for the I-45 until it actually hit 2 years. So right now, the only thing you can do is wait. Okay. Um, Again, if you are approaching closer to your mark, try reaching out. Okay. I've had cases where we have contacted USCIS, we have filed an inquiry, we've actually called or call them and let them know about the situation. Sometimes that may help your case in getting approved faster. Okay, again, you can try calling them or filing an inquiry or go to your local congressman if you're really approaching close to 2 years, or wait. So I would personally call them 1-800-375-5283. I would call them. I will let them know my I-130 has been approved. I'm still waiting for my I-45, and they will let you know whether you are in normal processing times or not. If they say you are currently in normal processing times, the only thing you can do is wait, okay?
Just to give some, also provide more information on Elias's question, it's not really over until you don't have that green card in hand. So they can tell you at the interview that you've been approved, and then they can hit you with an RFE. So
Correct.
if they told you you were approved, until you don't see that green card, you don't have that green card in your hand, don't believe anything that they tell you. They could tell you you're approved and you walk out of there and they're like, wait, we have actually this question, let's send an RFE. Well, I
Yeah.
was told I was approved. Well, now they issued you an RFE. Or I've also had clients where I have a straightforward case and they get the letter. They'll give you a white letter at the interview. Again, it's not over until it's really over. The letter basically means thank you for coming into the interview. We've completed
Hmm.
this process. Now we're just going to review your paperwork. Clients all nervous. And then the next day it's approved. Again, it's not over until it's actually over. I had a client that they had their interview in July. They got approved in November. That was about 5 months, almost 6 months actually. I have another client had their interview in May. We are 7 months in, and they said, "Hey, stop giving us a call. You can't call us until 2027."
Hmm.
So, that's just the thing about being in the green card process. Unfortunately, is that there are no two time frames the same, and it's not over until you actually have that green card in your hand. Then that's when your process is completely over. Um, I say call them, but also don't get discouraged if they say don't continue to contact us anymore. You can still continue to contact them, but if to them you're still within that normal processing time, they're just going to continue to ask you to wait, and there's nothing that can be done except waiting at that point.
Yep. And remember, right now, the normal processing time is well over a year, okay? So it's closer to 2 years. So, um, again, don't get discouraged if they say you are not, you haven't reached that processing time yet.
Hmm. I'm actually going to check the website and see what their processing time says, but it's probably 35 months.
Okay, Brenda. If someone has their Hello, Brenda. If someone has their 40 quarter credits, do they need a sponsor for marriage-based AOS only married 1 year? Okay, so if you have your 10 years and your 40 credits, you do not need a sponsor. Okay, you just need to supply sufficient evidence to USCIS, such as your SSA statement, and you need to ask to be exempt on page 8 of the I-45. I would also include if you have all of your EAD cards as well, and this will be suffice to show USCIS that you do indeed have the 10 years and the 40 credits. Okay, you have to have 10 years of work, 4 credits per year. Okay. Um, it has nothing to do with marital evidence, so it doesn't matter if you've only been married 1 year. Okay.
Also, be prepared to get an RFE after that.
Yes.
Just a heads up, you're going to get an RFE. Nothing you're doing wrong. USCIS, this is just an error in their part. Absolutely everybody. I'm not everybody. I think I have one client that I don't know, they got
Same
away with
here.
it. They didn't get an
Same here.
RFE, but I was actually expecting an RFE from them. But
Hmm.
it's not that applicants are doing anything wrong. It's just that's a mistake from USCIS's part. If you're going to be submitting the 40 credits, you're going to get an RFE. Respond again, the same thing for your SSA statement and your a
Page
letter
8.
explaining I have my credits, and page 8 of the form I-485. Um, and that's it. But you're gonna get an RFE, so don't get discouraged, Brenda.
Just make sure you have those 10 years and the 40 credits, 4 credits per each year, okay? And if you're not sure, you know, hop into our AOS Facebook group. You can ask, we'll be happy to answer your questions in there as well, okay? Ellie, are you still looking at those time frames on USCIS website?
No, no, no. I'm sorry. It gives you field office by field office. One says 12
Mhm.
months, one says
Yeah.
14 months. It just depends where you're at. It's closer to 1 year, over 1 year. So again, don't get discouraged. Now, we have had some cases that move pretty quickly, 2, 3
Yeah.
months, but that's not going to be everybody's case.
No. Jessica. Hello, Jessica. Good morning. I am applying for my citizenship application. However, when I initially did my green card application, I used an attorney. I don't know if she requested a FOIA for me. Anyway, I ended up doing my FOIA on my own and just received it back. My USCIS FOIA does not indicate any removal, deportation, or voluntary departure, nor does it mention criminal records. Only states my DACA and green card application. I wasn't able to obtain my CBP FOIA as they requested a notarized request letter. Should I request my...
I think some of it cut off.
Yeah. Let's
Let me
see.
see if I can see it on Facebook.
Okay.
Okay, it says, should I request my CBP FOIA or should I just go ahead and apply for my citizenship? I don't know why I'm overthinking this. I just want to ensure I file everything correctly and I'm not overlooking something that would negatively affect my citizenship. Any suggestions?
Okay, so that is certainly up to you. I mean, if there's something of concern there, then you definitely want to obtain that CBP FOIA. But again, that is totally up to you. If your record indicates no removal or voluntary departure or criminal records, that's great. But remember, if you are concerned about something, definitely try to retrieve that CBP FOIA. Okay, that CBP FOIA, it does indicate, if you've had any interaction with Customs, Border Patrol. Okay, so again, if you are concerned about, obviously, it's safer for me to say yes. Try to obtain that CBP FOIA, especially if there's an area of concern. Okay. Hello, Teodulo. If my sister, U.S. citizen, has already petitioned for my mom under 245I, can she petition for me and include me under the 245I so that I don't have to leave the country? Okay, so a sibling to sibling petition, it does require consular processing, but obviously, if you are covered under 245I, you can certainly adjust in the US, but you have to keep in mind that sibling to sibling petitions take a very, very long time and it depends the country that you are from, okay? And obviously there's a lot of paperwork that has to be I guess you could say thoroughly reviewed and then, make sure that 245I it really did cover. It was really, approvable upon filing April 30th, 2001. So your US citizen sister, if you guys are covered under 245I, a petition was filed for your mom and it was approvable upon filing, filed before April 30th, 2001, then you may very well be covered under 245I now. Your sister may petition for you, but you have to keep in mind that these petitions take a very long time and it depends on the country that you are from. Okay. Um, and another
I
note
would say,
also, go ahead.
not to discourage, but if you're from Mexico, it's gonna be 20 to
Yeah.
25 years.
Yeah. I didn't
That
want to say Ellie, but I was like, we're looking at a
I
20-year wait from
it's
Mexico.
gonna be it is now if you're in a different country, it may be a shorter time frame. And the reason I'm saying this is because is it doable? It's possibly doable, but you're gonna have to wait a very, very, very long time. What happens is with your sister petitioning for your mom is an immediate
Immediate
relative of a
relative.
U.S. citizens. The number of visas for that category are unlimited. Okay, your mom doesn't have to wait for a number to be available for her. Now, because you are the sibling of a U.S. citizen, you have to be placed in a waiting line, and there's a
F4.
backlog. If
Mhm.
F04. If you're from Mexico, and I'm only assuming that you're from Mexico, you may well not be from Mexico, and I'm sorry if you're not. But if you're from Mexico, it's about 20 to 25 years. So if you let us know which country you're from, I can kind of tell you how
Yeah.
much before there is even a visa available for you, because they give those a certain number every single year, and people are waiting from the 2000s. I think they're in 2000s right now, if I'm not mistaken, from Mexico. Will you be able to adjust? Possibly. Maybe you'll take Mexico. Okay, so let's say in 25 years, you'll
Yeah.
be able to get a green card in 25 to 27 years, because you have to be placed on a waiting list for a visa. Again, not to discourage you. You may very well want to do it and wait 25 years. Also, just depends. Is your mom becomes a citizen, or it may be faster.
Actually, yes, yes, I was about to say, because right now we're looking at F4 categories in Macedonia, we're looking at 15 years or more, okay? Um, if your mom becomes a citizen, she may petition to you as an adult child. Right now, I know those now for Mexico, again, they have a longer wait than Macedonia, but right now I can tell you Macedonia, it's about 8 or 9 years. So that is another option you may want to look into. Maybe when your mom gets her citizenship, maybe she can petition for you as an adult child. Maybe it will be faster than the F4 category of your sibling petitioning for you. But if you are covered under 245I, you may, you know, go through the process here, okay, instead of Conster. All right, now let's see. Ipanda, hello Ipanda. Hi, so I had DACA and was working with my permit, and now I'm a green card holder. Do I need to let my employer know or anything? And it's good to let your employer know that you have your green card, yes, because you will no longer need an EAD with your social security card, okay? You have your green card, your social security card, and it has, because you are a green card holder, it has lifted restrictions of needing an EAD card with your social security card. So definitely let your employer know that you are a permanent resident and you no longer need that EAD card associated with your social security card. Your social security card number will remain the same. You will no longer need that EAD, okay?
If they e-verify, if your company is obligated to be in compliance with the I-9, their I-9 system should trigger that your DACA whenever your DACA is about to come. So at some point, you're going to have to update them. Just go ahead and update now.
Hmm. Yeah. Congratulations.
Wait, was there an Ipanda on our live last week? When did you get approved, Ipanda? I think they were asking questions last week. Um,
All right.
and
So,
Teodulo is from Mexico. I was
yeah. So, you know what, Tadulo? I would say look into look into it when your mom becomes a citizen, and I think her petition is going to move a lot more faster than that F4 through your sibling, okay?
I actually looked at the visa bulletin board, and it depends married or unmarried. Unmarried
It's a little
is going
faster.
to be about 7 years
Hmm.
faster,
Yep.
but married is going to be about the same thing as a sibling petition. I mean, it's not a bad thing to have, because you never know, when laws will change, just like they
Yeah.
did April 30th of 2001. You don't know when it's going to change, if it ever changes. If you want to have that person submit an I-130, if you have DACA, but again, it's 25 years or so, give or take.
Hi, Gris is asking a question. Ali, can an applicant under USCIS sibling be filed to get in process, and can the application be changed in the future if married to a US citizen? So
Mm,
basically, Gris, I kind of know where you're headed with this, and Ellie, please correct me if I'm wrong. I think she wants to know if a sibling can start the AOS or the consular processing. If a sibling can file the I-130, and then once they marry a U.S. citizen, if that U.S. citizen can take over, no, you can't do that. Okay.
you have to have an I-130.
If the sibling starts that process with the I-130, the sibling has to finish. If you get married to a U.S. citizen, that I-130, you need to terminate that and do an I-130 through your um, U.S. citizen spouse.
Again, it's because it's different categories, and with a sibling, you're going to be placed in a line. Now, you want to move up the line, they're not going to automatically move you. You have to again do the I-130. And
Through your
if
spouse.
you're a spouse of a U.S. citizen, if you're a spouse of a U.S. citizen, if you're a parent of a U.S. citizen, or if you are a child unmarried under the age of 21 of a U.S. citizen, and you have a legal entry, you don't have to wait for a visa to be available in that category. Those three categories that I just
Immediate
mentioned,
relative.
they're immediate relatives, they're immediately available. The only thing, if you have to have the I-130 approved, um, and if you qualify, you can go with the adjustment of status, versus parents of residents. Parents of residents don't qualify for green cards. I lost my track of thought. Let me see, what was the category? I just had it.
So
We have the unmarried sons and daughters of U.S. citizens. That's consular process, placed on a waiting list. Spouses and children, unmarried sons and daughters of permanent residents, also consular process, unless they have 245I. Spouses and children of permanent residents, consular process, unless they have that 245I. Unmarried sons and daughters of permanent residents, also consular process, unless 245I. Married sons and daughters of U.S. citizens and brothers and sisters of adult U.S. citizens, also
that's
consular
consular.
process, unless 245I. So,
Thank you, Ali.
mhm.
Paula, for proof of the 40 credits, would one present a social security statement? 4 pages. Thank you. Okay. Um, it's basically that main page with it's kind of looks like a barcode, and then that second page where they have all the 10 years and they have um, those boxes with the numbers in them. Okay. I know there's like another 2 pages and they just give you general information. No, it would be, listen, if you submit all four because you're not sure, go ahead. It's not going to hurt you. But it's just those main 2 pages, the one with like the barcodes, the ones that looks like, the graph with the barcode with the bars, and the second page with the years and the numbers. But if you submit all 4 pages, it's not going to hurt you. I know that people like, they get scared, so they do that anyway. So if you want to submit all 4 pages, that's fine. But the other 2 pages are just some general information, okay? Ipanda. Okay. Another question. Hi, Panda. My mom is from Mexico and she's with a US citizen and she did not come in with a visa or anything. She's been here more than 40 years. I think she can apply for a green card if she gets married with a US citizen. And what's the process on that if it's a good thing? Okay. So, if your mom did not come in with a visa or anything, um, she's still required to have a legal entry to adjust her status here in the US, okay? It doesn't matter if she's been here 40 years, she needs that legal entry, okay? Unless, you know, she
Ipanta
had
joins the
someone,
military.
or, or, um, maybe she had someone, a brother or an employer, file a petition under 245I back in the day. She can be covered under 245I, and then her US citizen spouse can petition for her. But Ipanda, your mom needs a legal entry. A legal entry, or if maybe she was covered under 245I, maybe a petition was filed for her under 245I. Or, as Ali said, if you've joined the military, she can apply for MPIP, okay? So, regardless, if she was to file a petition, and she doesn't have a legal entry, her next step would be consular processing, okay? And that's a whole nother ballpark right there. She's going to need a waiver. So, again, in order for your mom to pursue AOS here in the States, she needs a legal entry or she needs to be covered under 245I. And that means she doesn't have to leave. In lieu of that missing entry, she can use that 245I, or you can join the military and she can apply for MPIP. So again, she needs, please understand, before she proceeds, she needs that legal entry to adjust here in the States, whether it be through you joining the military, 245I, or, again, that legal entry is very, very important. Okay. If she moves forward without it, it's going to be consular processing. Just please make her understand this. Okay. It doesn't matter if she's been here 40 years. In order to adjust your status here in the U.S., you have to have been married to a U.S. citizen, spouse, or child, and have that, legal entry where you did enter with inspection, admitted, paroled, or inspected. Okay. Teodula, if my mom's case got approved under 245I and 5 years later she became a citizen, could she petition for myself under the 245I since her case would be closed? Could the 245I still apply for me? I'm just trying to avoid. Teodula, yes. If your mom's petition back when 245I was around, if it was approvable upon filing and it was filed before April 30th of 2001, and she's now a citizen. Yes, you can still benefit from 245I as long as it was approvable upon filing, okay? And it was filed before April 30th, 2001. You can still be grandfathered into that petition. Yes. Hopefully it will help you avoid leaving the States, and your mom's a US citizen and she could petition for you here in the States. But you have to just keep in mind, even if you are covered under 245I and your mom files a petition for you, it's going to take, a while. But, I'm just letting you know based on what the information you're providing here. But in order for in order to really, we have to thoroughly review whether you are covered under 245I, okay? So, if you would like to schedule a Q&A and submit the paperwork, we'd be happy to take a look and let you know. Rosa. Hello, Rosa. I had a case with Child Protection Services. I was sent a copy of the case investigation. This was years ago. I'm not sure if this is what I need or I'm doing. I had a case with CPS. I was sent a copy of the case investigation. This was years ago. I'm not sure if this is what I need or I'm doing. Okay. You're asking
Before you
it.
go, P, I'm sorry to interrupt, but before you go, I'm not sure if Rosa is one of our clients. And if she is one of our clients, she needs to reach out to her caseworker and ask them this because I would not like to give them
No.
different information than what their caseworker is already telling
Yeah.
them. But if I'm not mistaken, I think she's a client. And I'm
Okay.
sorry, Rosa, not that I don't want to give you or want to help you out, but we want to just make sure that you have the correct information. Go
Yes.
back to your caseworker if you are. Now, if you're not, let us know. Um, but
Yes.
I think she is.
Yeah. And I personally wouldn't provide, you with advice directly to your case. I would just say, it depends. Um, you know, and I can't provide you directly. I cannot provide information directly on your case because I don't know your case. So again, as Ellie said, go back to your caseworker or you know, book a Q&A with us or an appointment because again, I can't give out legal advice for a case that I really don't know what's going on with or anything like that. Okay, so Rosa, again, just please, per Ellie, please reach out to your caseworker. Okay, no cases are the same, and um, we cannot just give out direct information for these type of questions. Just general today, but if you go back to your caseworker or you book a Q&A or you want to meet with us, that's fine. But we can't just, based on what you told us, we can't just give you direct information here on the live today. Okay.
Yep, there's a couple of questions actually, and it's too personal information. We'd
Mm-hmm.
have to ask you what it was for, and we don't want you putting all that information. So if you are, and again, the reason I think I saw you, Rosa, and I think we talked about this. That's kind of why I'm like, I think she is one of, reach out, and let us know, and we can go over it, but more privately because a CPS case, we don't want to put all that information out there.
No. Even if it's an arrest or something like that, I mean, you don't want to put yourself out there because again, there are penal codes we have to look at. We have to look at the penal code, whether it was a misdemeanor, whether it was a infraction, whether it was a felony. Like there are penal codes to each case, and we have to determine what that penal code is to your case because no, two people can have the same arrest, but one can have a different penal code to their state and the other one can have a different penal code. And we have to look these penal codes up and determine, if it's something we can take on, if we would refer you out. Again, no two cases are ever the same, especially information like this. We don't want to, put any additional information out there when we need your paperwork and we need to determine, okay? Okay, Panda, does it have to be me as a green card holder or can my brother, a US citizen, join the military? If you can just elaborate your question a little more.
Ipanda is the person that their parent has been here for 40 years, married to a U.S. citizen.
Okay. Well, I believe that a green card holder can join the military. Correct me if I'm wrong, Ellie.
Yes, they can.
So you
But
can,
it doesn't have to be them. It can be a sibling as
that's
long as
right.
one of her children
Yeah.
get her
So,
MPIP.
yep, just like Ellie said, if you're a green card holder, you can join the military. If your brother joins the military, that's fine. It can be, either sibling, and it would be something that can help her, apply for the MPIP. Hi, Salvador. My child will turn 21 in 3 years. I am a DACA recipient with AP. However, I did accrue illegal time before becoming a dreamer. Will it be a problem when I do AOS, having accrued illegal time? No, it would not be a problem if you are adjusting your status here in the States. Um, you know, the only time really when it becomes an issue is obviously if you consular process, you're going to need a waiver, okay? Because it depends how much illegal time how much unlawful presence you have accrued. Again, we have not seen it become an issue if you are pursuing AOS here in the States through your U.S. citizen child or spouse. But if you are to consular process, please keep in mind it depends on how much time you will need a um, waiver. Let's see. I also want to make a point that for those of you who are applying for removal of conditions, the I-751, um, if the marriage does not work out, if the marriage does not work out and now you would like to file for the I-751, you can, but there is a waiver involved with that. Okay, it's a whole process because you have to show USCIS that you were in the marriage for good intent. Okay, if you are getting closer to your 2-year mark, there is a calculator on the USCIS website, and you can input your the information that they request, and that will let you know when you can file for 755 removal of conditions. Okay, with that application, just please keep in mind that they are going to want marital evidence, preferably from the day after that green card, that temporary green card was approved. Okay, so you will need to show them um, additional marital evidence when you file for removal of conditions I-751, preferably after that date that you were approved for that conditional green card. If the marriage does not work out and you still want to file the I-751, you can, but you are also going to have to submit a waiver with that as well, just to show USCIS, that you were in it for good intent. And this is just some information on the I-751. Oh, we have another question, I believe. Let's see, Rosa. Okay, so Rosa, again, please reach out to Vanessa. She'll be more than happy to explain a few things to you. We are all here, so just please reach out to Vanessa, and we will be more than happy to answer your questions. Okay. Okay, Salvador, again, accrued illegal time was 4 years ago. Okay, but that has nothing to do with you adjusting through your child or your U.S. citizen spouse. The only time that it will become an issue if there are illegal multiple entries. So you have to kind of be careful how you move forward if you have those. Just please reach out to an attorney if you are concerned, okay? All right. I think that's it today, Ellie. Anything else you'd like to cover before we go?
No, it was a pretty good live. I think we
Yeah,
covered a lot of questions.
yeah, you did. Actually, there's one more thing I kind of wanted to speak about really quick, but Ellie, go ahead while I'm looking it up, okay?
Ipanda. Okay, so after ID joined the military, how soon can she start the process and how long does she have to wait? So whenever you start if you join the military as a resident, it'll also speed you so you can get your citizenship earlier. Once you get your citizenship, then you can start the parole in place for her. Um, first step is joining the military. Um, join them if I would go speak to a recruiter if this is something serious. It doesn't have to be active. It can be reserves as well.
Correct.
Okay. Very important. You do not have to be active. You can be in the reserves and your parents or your spouse or your children under the age of 21 unmarried could qualify for the military parole in place. Um, once you do join the military as a resident, it speeds up. You can become a citizen, and I believe it's a year. And once you become a citizen, then you will file for that military parole in place for your parent. It takes anywhere from, I will say, 6 to 12, 6 to 18 months for that military parole in place to be approved. That's going to be her legal entry. She's going to have that protection. That's going to be her legal entry so that she does not have to leave the States. Once she has that I-94 with the military parole in place approved, then either you, U.S. citizen, child, or her spouse can file that petition for her. Um, I can't really tell you how much time it would be because it just very much depends on how fast, USCIS moves, but that's kind of give or take kind of the time frame. So it'll be a couple of years, because of course you have to be a citizen first. But I think it's doable. It's doable. I have seen a couple of cases where they became a legal resident and they joined the reserves, the army, one for the benefits, two so that their parents could also benefit from military parole in place. And they had successful cases. So it's very doable.
Thank you, Ellie.
Mhm.
Okay, so before we go, for those of you that have renewed your DACA, when it comes down to the work permit, the I-765, USCIS is sending out corrected notices, okay? All right, so let me see here. All right, so USCIS might send you a corrected notice for those of you that have renewed your DACA and you have filed the I-765 application for employment authorization. Um, those notices, obviously notice type receipt notice for the amount received of 470, class requested C33. Basically, this application is filed along with your DACA renewal. There is a corrected notice, and they're letting you know that, let's see here. They have received your electronically filed application on or after October 30th, 2025. Um, they sent you some type of notice letting you know that you were there was going to be an automatic extension for your EAD. Okay, so on these corrected notices for you DACA recipients that are renewing your DACA for the I-765, they're letting you know corrected notice is letting you know that you know it was an error on their part, that there is no automatic extension for EAD renewals under DACA. Okay, so you might get a corrected notice. Don't be alarmed. It's just letting you know that, hey, we made a mistake. There is no automatic extension for I-765 under DACA. All right. So I just wanted to, you know, let you guys know that if you get one of those corrected notices, don't freak out. It's just letting you know, no, we made a mistake. There is no automatic extension for EAD cards under DACA, letting you know that your EAD under that renewal is pending. All right, you know what? I think we have one more and then we are good to go for today, okay? Uriel. If someone is married, can they still be petitioned by their parent? Yes. Okay. So basically, I'm just going to reiterate what we went through earlier, okay? If you are married and for some reason your spouse cannot petition for you, your parent can petition for you, but that is constant processing and that takes a very long time. Now,
U.S. citizen parent. I'm sorry.
yes, thank you, Ellie. Now, if you know you are covered under 245I and your US citizen parent petitions for you, that's fine. You can wait here. You can adjust your status here, but it takes a very, very long time. So good news is you can, wait here and you can adjust here when your priority date is up to date. And that would be on the visa bulletin. So yes, it's doable, but it takes a very long time. And if you have 245I, you can adjust in the States. If you don't, it'll be constant processing. So I hope that answers your question. And you can also rewatch this live. We spoke about it a little bit more. We went in more.
I'm
We went into a little more detail earlier.
and I'm gonna just say this, even though they have that kind, they came with a visa, it doesn't matter. It
Correct. Doesn't
doesn't
matter.
matter. Here what matters is, do they have 245I? If
Hmm.
it's if they're not spouse, child, or parent of a US citizen, then it would be consular process. For consular process, it doesn't matter if they came with a visa or if they have DACA. What's gonna matter is, do they have that 245I or not? Now, if their parent is a resident and they're married, their parent cannot file a petition for them. Only if the parent is a U.S. citizen can file for a married child over the age of 21. But if she has that kind, she came in with a visa, she's still gonna have to do consular process. The only thing that's gonna matter is, maybe she has 245I. How did her parents get their green card? How
Yeah.
did they become a U.S. citizen? That's
Correct.
what's gonna matter. But DACA and a visa for categories on the visa bulletin board, they're still going to be considered processed, and it doesn't matter if they have DACA or came in with a visa.
Correct.
Now,
And if you
maybe
are
you're a U.S. citizen. Go ahead. I'm sorry.
no, 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 go ahead. No, I was gonna say, Ali, even if you are covered under 245, I remember, if you are over 21 and your U.S. citizen parent files for you, it's gonna be a long wait, and
Hmm.
depends on the country. Okay. All right. So one more, and we're good to go. Brian, I'm trying to travel from Arizona, I'm assuming, to Florida. Any issues? Okay, so as Cook says, just keep all your DACA paperwork with you. Okay, keep your DACA paperwork with you, and you know, we never guarantee, but as Cook says, travel, but with your DACA paperwork with you. Okay. All right, I think we are good to go for today. Anything else you would like to share before we go, Ali?
No, there's too much information to
Yeah,
share on these 30
there
minute
is.
lives.
There is. Yeah. So we'll come back next week, and we'll go past the 30 minutes. I think we have, but we have one more
45
question.
minutes.
Yeah, and we're good to go. Okay, Maria. Hi, Maria. Can I do AOS in Texas and then move while that's pending processed, as long as I inform them of my move? Yes, yes. You can. You're in Texas right now. You can file the paperwork. That's fine. Um, Again, there is no final ruling on DACA yet, so generally it's not going to affect anyone filing for AOS because even if you live in Texas and your AOS case is pending, you won't accrue any unlawful presence while that case is pending. Okay, so yes, you can go ahead and file your AOS paperwork. There is no final ruling yet, and I basically state that that has nothing to do with AOS. That's basically letting you guys know there is no final ruling yet. Okay, um, so okay, yes, you can file your AOS packet and then let them know when you move. Just please keep in mind that you have to, for anyone, whether you live in Texas or not, if you move, you have to notify USCIS within 10 days of that move. And how you do that is you go onto the website and you just submit a change of address, okay? In 10 days.
Can I add something to
Yeah. All right ahead, Ellie
that?
was waiting.
I'm sorry. So whenever you move, remember that your field office is gonna move as well, okay?
Yes.
So
Yep.
I mean,
And then,
it may not change a lot, but your field office is gonna. It may depend on where you move. It may
yeah. Yes.
they'll move your case to the field office, and then
Yeah.
so
I
just
mean,
an FYI on that.
yeah. And what we're trying to hint at is that some field offices are taking longer than others. Definitely. I mean, hey, I can tell you right now, Texas is they're pretty fast with their field office down there, at least from what I'm seeing.
Let's see. Houston, Texas, on their website says,
I don't go by the
sorry,
website.
service is temporarily unavailable. Of course it is.
Okay, so guys, get your questions ready for next week, and we'll see you all then. Happy holidays, warm wishes from our families to yours, and you know, please ask questions before you submit packets, your AOS packet on your own. Book a review. We'll review your packet. Just if you have questions, please get them ready. Please ask them. Don't assume it's not a big deal. I just submit my packet and then you get hit with an RFE and then you can't find paperwork or your paperwork's been expunged. You don't want to run into those issues. What you want to do is educate yourself first, okay? Before you submit your packets. So get those questions ready. You guys can ask next week, book your Q&As with us, but just please, oh, I was arrested when I was a juvenile or whatever. They're not going to want the paperwork. No, they're going to want the paperwork. So this is just an example of something I'm letting you guys know, okay? It doesn't matter if it's a restraining order. It doesn't matter if it's something that happened years ago. Everything has to be thoroughly reviewed before you submit that AOS packet. Okay. So happy holidays and warm wishes from our families to yours, and we'll see you all next week. Have those questions ready. Bye.
Yes. Bye, everyone.